Senate chamber. Sound. 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 Committee room 21. 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 Sound. Committee Room 21, signed. 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 Committee Room 21. 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 Sound. 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 Committee Room 21. Sound.
Okay, good afternoon colleagues, and can I welcome you all to the second meeting of the ad hoc committee. We have quorum, so we'll open up into public session. For members' information, we will receive information, a oral briefing from the Northern Ireland Assembly Commission. Apologies, I've received one from Mr. Daniel McCrossin, and we're joined online by Padraig Delargy. Chairperson's business, members, I have none. So draft minutes are at page 6 of your pack. Are members content that I sign those a true and accurate reflection of our deliberations? Agreed. Thank you. Moving on to item 4 then, matters arising. Is there any issue that members wishes to raise at this stage that's not covered in the business later on? No, if not, then let's move to our oral evidence session, please. Okay, colleagues, will now receive oral evidence from the Assembly Commission, and we have papers in our packs at page 15 and at page 3 of our table pack, which was sent out yesterday. Hello, Sinead, how are you?
How are you?
Okay, colleagues, most people you should be aware of all our guests. You're all very welcome. In particular, can I welcome Andy? Andy, congratulations on your achievement. You've done yourself and all of us very proud, so congratulations. Andy Allen, Australianist MLA, Trevor Clark, DUP MLA, Sinead Ennis, Sinn Féin MLA, Nuala McAllister, Alliance MLA, and Colin McGrath, SDLP MLA. Leslie Hogg, Chief Executive and Clerk to the Assembly, and apologies, I can't quite read your... Yeah, you're very welcome as well. Okay, we're delighted to have you. I'm happy to hand over to you if you wish to make any opening statement at this point.
Okay, thank you, Chair. Thanks very much, and thank you for inviting us here today. So if you don't mind, I'll just make some opening remarks,
yes,
and
please.
then I'll pass it over to yourselves for any comments or questions. The Assembly Commission, as I said, we're pleased to be here today to assist the scrutiny of the Assembly Members' Remuneration Board Bill. I'm conscious that we have the second stage debate in the Assembly Chamber on Tuesday, and that you have received the briefing paper from us for today's session. Therefore, I'll just make a few general points rather than go through all the detail of the bill. So let me begin by acknowledging that none of us in the Assembly Commission, nor I suspect any of you in this ad hoc committee, are particularly keen to be spending time discussing issues related to members' salaries. We will come on to the legal reasons why it is necessary to address these matters, but it is important for us to keep returning to the point that what the Assembly Commission has brought to the Assembly is largely a technical bill which is focused on issues of process. This bill does not deal with what salaries should or potentially will be. The discussions around the development of this bill began 10 years ago, long before any of the current Assembly Commission members took up office. And we want to place on record the thanks of the Assembly Commission to all of the Assembly officials who have given their expertise to assist the Commission in its review of options for the reform of the system of financial support for members and in the development of this legislation over that 10-year period. I'm not going to go back over all that history for you, but you will know that on the 30th of June 2020, the Assembly passed a resolution to give the Assembly Commission the power to make determinations on members' allowances. At the same time, it agreed that decisions on salaries and pensions should be made by an independent body. Therefore, that has now been the settled practical position in law of the Assembly for some 5 years. While that resolution conferred functions on the Assembly Commission, the Commission made it clear that at the time that further legislative change would be needed. That is because technically the Independent Financial Review Panel retained power to make determinations on allowances for members' offices under the Act passed in 2011. The Assembly Commission first brought the Remuneration Board Bill to the Assembly in December 2020, but did not take it further in recognition that the Assembly had other priorities, including the pandemic. However, we have been advised throughout that the legal position needs to be regularised. Therefore, this bill has 2 core objectives. Firstly, it regularises the legal position by reflecting in law the position that the Assembly resolved in June 2020 and again earlier this month. Secondly, this bill establishes the Remuneration Board to maintain an independent body to determine members' salaries and pensions. The explanatory memorandum to the bill sets out the process which was undertaken to develop this bill, including the different options considered. It is worth noting that among the legislators on these islands, there is no set way of dealing with these issues. In Scotland, the Scottish Parliament corporate body, which is the equivalent of the Assembly Commission, continues to take decisions on the level of salaries and allowances available to members. In Westminster and Wales, decisions on these matters are taken entirely by independent bodies. Even within those arrangements, there are differences. For example, at Westminster, the Independent Parliamentary Standards Authority is legally required to appoint a former MP to its board. Therefore, the Assembly Commission is proposing a hybrid model in this bill, which includes elements of different arrangements elsewhere, which it considers best meets the needs of the Assembly. The Assembly Commission conducts its business by consensus as far as possible. The fact that we are all here today underlines that after years of discussion, the 5 parties represented on the Assembly Commission have reached consensus on the approach laid out in the bill as being the best way forward. Over the past couple of weeks, there has been a certain degree of misinformation regarding the bill. Therefore, I think it is appropriate for me to end by making it absolutely clear that the core principles of this bill for the Assembly Commission is that the salaries and pensions of members should be decided completely independently. At no time has the Assembly Commission discussed or sought to agree what the salary of a member should be, nor will we. We are wholeheartedly agreed that an independent body alone should decide what that is, and that is what the bill provides for. So, Chairperson, we look forward to assisting the committee over the next few weeks and months, and we will together seek to answer any questions that the committee now has. So, thank you.
Okay, thank you for making that comment on behalf of colleagues represented here today. Just looking at the bill itself then, so Clause 1 I think is pretty explanatory and routine, so I don't have any questions on that if members do. No? Okay. Clause 2 then, and you outlined this in your opening remarks, Sinead. So it's already the settled will of the Assembly on a number of occasions that determination in relation to members, staff and office running costs are done by the Commission, and that's already the case. And you had already outlined the dangers that if we don't pass this bill in terms of having 2 bodies being able to simultaneously set determinations. Is that correct?
That's correct.
Okay, perfect. Obviously, I'm a newer MLA. Some of you are more experienced than I, but I think it's just worth putting on the record some of the concerns that were raised by members of all parties in relation to the previous determination by the independent panel. I wasn't an elected member, but I did work for an MLA, and in particular the issues around the contracts that staff were issued were in no way comparable to other parts of the public sector. And then maybe you as MLAs could make some comments on the restrictions that were placed, particularly around not being allowed to advertise your phone number on your office or indeed your email address so constituents could contact you. So it'd be worth maybe just getting on the record some of those MLAs' views and some of the contact you as the Commission had from MLAs concerned about the previous determination.
Yes, so
I'm happy enough.
do you want to go ahead, Trevor?
Well, I think, Chair, actually you've outlined probably one of the, or 2 of the most concerning ones for members. It seemed irrational that a previous panel would decide that you can put a name on a sign but you can't put a number. Most of us, or all of us who come into public life, want it to be accessible, but for a former panel to decide that you can't have a number to advertise for members of the public to contact us, particularly those who are driving past offices at night, would have been easier to pick up a number to contact those offices during the day. The other one, I think it's, for me, it's a good change in terms of the maternity leave.
Yes.
I mean, I think some of the members, and indeed one of my own party colleagues, was affected by that at that time, and it inhibited her time and her time at home, unlike anywhere else within the public sector. She had to cut her period short. So I think those are just two good examples of some of the problems that existed with the previous determination.
Any member, anything else they want to add on that one? Colin, you probably operated under the previous regime?
No, I didn't
You
actually.
didn't?
I just came in immediately
Okay,
at the
fair
start of it. But I think it is, whilst this is that point is in some respects historical, this bill is not about allowances.
Yep.
This bill is about simply establishing a body to independently set the wages. But the sort of the history of it is that at a point those two had to be separated because of the reasons that have been outlined.
And that's then formalised in the legislation in clause 2 in terms of removal of that function from the independent panel.
It was just, sorry, Philip, just to add to that, that is why the Assembly Commission, before my time, obviously recognised there were problems in terms of the barriers that the previous determination had meant for members. So the Assembly Commission, obviously sought to address some of those problems, and that's why those powers were retained then by the Assembly Commission. And all members will know that the new determination was issued in this month, actually, earlier this month. So, and that sought to address some of the problems and some of the issues that previous members had faced.
Has the Commission received any complaints from any MLAs about the changes that were made?
Not that I'm aware of.
To the country, Chair, I mean, I said it just comes to mind when we're talking. One of those, the other changes is, given that determination was made in 2016 in terms of allowances for offices, whilst heating costs, energy costs was rising, and the restrictive amount of money that the offices had to survive on, that was becoming problematic. And some of our members within the Assembly were actually footing some of those bills themselves. So I don't think in any other place, or in any other legislator, that the members would be footing the bills to function in a constituency office. So, and as you'll know, some of your colleagues who raised it regularly within our meetings, and I know in other parties, who had to contribute out of their own finances to keep their offices open. So, I mean, and the period of time from 2016 to now, and no additional allowances allowed for those running costs, I think again speaks to how poor the previous determinations were.
And Chair, if I can come in, another issue Trevor has already said around maternity, and I think, for any organisation or public body to not have maternity allowances and allow appropriate maternity leave for their staff is simply not acceptable. It wouldn't be accepted in any other workplace, so I think that's something that should massively be welcomed. Another one of the issues that we have received feedback that is positive is around the disability access and requirements for constituency offices, not just for staff but also for constituents as well, and this now allows MLAs to actually ensure that their offices are accessible in every way, through whether it's the software they use, through the communication with constituents, or should any of their staff also require it, and that's something that we've had feedback on that is certainly being welcomed.
If there's no others, then if I just move then to clause 3, which is in relation to consideration in other legislatures, the public commentary has probably been very different from the factual basis of the bill that's set out before us today. So just to read in that it says that have regard to salaries in other parts of these islands. There's nowhere in this bill that it says it must be the same as, or must be a percentage of, and I suppose that goes to the point that the Commission opened up with earlier, was that you haven't had any discussions about what the salaries should be, what you would like them to be. Your view is that will be done independently. In terms of what is included in the bill, is that simply benchmarking or exercises that would be carried out in other issues of public sector pay?
I think, Chair, it's reasonable to assume if anyone was looking at any form of employment that you would benchmark against something that's comparable. I'm not sure why we would ask them to take regard to any other form of employment other than the line of work that we're all involved in. But people listening need to remember it's take regard to. It's not saying you must follow. We're actually asking them just to look at that, look what they're doing, look at the comparables and consider the salaries with those in terms of their function. I think it would be bizarre for us to suggest take due regard to some other form of employment, and then I think we would be open to criticism. So I think that's actually important there, and indeed I'm sure it's similar in other places.
I was just going to say, just on that point, Chair, if you don't mind, I think it is important for maybe just to outline, with this being in the bill, it actually doesn't tie the hands of the independent board. So effectively, whilst it does say regard to, the reality is the independent board will decide, what it should be. So what I'm saying is, because it mentions these other legislatures, it actually doesn't mean that they actually have to take that into account at all. They just have regard for it, but it doesn't mean that they're tied to having to do what they have done.
A very interesting point, because actually if you look at the previous determination and some of the critics that made the previous determinations, they have actually taken due regard of another place and compared our salaries, but suggested it's 65 percentile of that figure. So they've already taken regard in terms of the previous panel. So I think it's reasonable for the Commission to assume that the next panel should also take regard, but wherever they land at, that's up to them. We have no say in that.
And Chair, just to add to that, while it does require the board to give regard to, it doesn't prevent the board from taking into consideration any other circumstances or factors that it may feel relevant when it comes to making the decision on salaries.
And sure, if I can also come in there, I think because there are concerns publicly that we are not discussing salaries, but we must also face up to the realism that there will be a comparative nature towards this. But we do have a different population size, we have different constituency sizes, so all of these things will be taken into account, and rightly so, whenever they are making their comparisons.
Okay, thank you. Just then turn to Clause 5, membership. So my understanding of reading this is that, contrary to some public commentary, that there is no guarantee that a former MLA will be on the panel, that they will have the same right as any other member of the public to apply to be on the board, but there's no guaranteed outcome on that. I'm just keen to get the view of the Commission in terms of the merits and demerits of Clause 5 of the bill.
So this is something that we talked about. I'm relatively new to the Commission in the past year, but I know from the previous Commission there was a lot of discussion around this, and the best option was to remove the disqualification whilst not actually making it compulsory. That someone who is a previous MLA would sit on the board. Whenever the previous independent panel did sit, they did make reference a number of times. Both references were explicit and implied regarding IPSA, and that being the gold standard as to how to apply the information around member salaries. And if we are to take that into account, then we must actually look at what IPSA does, and they actually legally require a former member to be on that panel. We didn't think that it was necessary to actually do that. That probably is a step too far, particularly with the nature and the size of the Assembly. We felt, though, that if a particular former member did want to, that we shouldn't disqualify them. And also, it is like, it's honest to say that an MLA will have insights into the role. We previously discussed the issue of not being allowed to have a number on your sign. I mean, if there was a previous MLA sitting on that board, they would have said, come on, that's nonsense. How is the public supposed to contact you if you're not allowed to advertise what your phone number is? Mm-hmm. So a bit of kind of realism put into that aspect too. I think it's important that insights are given, but it's not required. So should nobody apply, should multiple apply, doesn't necessarily mean that they would get it. And whilst we're talking about this, perhaps you'll probably bring it up as well, is that the Assembly Commission will have no role in what the criteria actually is for that open appointment process too. I think that's very important to set that out today. But from the introduction of the actual bill, we have had a subsequent meeting of the Assembly Commission, and we have noticed that there's actually an amendment that we would potentially like to make to the bill, and this is around should we need to make temporary provisions for a temporary appointment to the board. The current legislation actually allows for that temporary appointment to be made with disregard to the element of not being able to have or being allowed to have an MLA or previous MLA on it. So in essence, you could technically have two, but we're going to actually remove that requirement of the temporary provision so that actually it would stand by the same guidance that we have and that we want the aim that we want to have. We haven't got the wording of that yet, but we have discussed that we want to remove any loophole that changed it significantly.
Chair, it's worth noting or adding, just to remove any ambiguity, if, and I think Nuala's outlined it correctly in terms of whether someone applies or not, but people need to bear in mind it's one of three. Mm-hmm. So the former member has not got any more control than the other members. Indeed, he's only a third, or she may be a third if they apply. But I think it's important that people listening recognise that the former members bringing that experience that Nuala's outlined, but they're only bringing a third of the committee and they haven't got the balance.
Just on that point around the former member, I want to come back to the point you made now about the temporary positions, but on that, Trevor, is there anything that could prevent a former member sitting on this board and then after that standing as a candidate in the following Assembly election?
Well, I suppose, there's possibly not, and I suppose that could be amended if that was a concern. However, I go back to the point, if a former member applies and if a former member is appointed, they only carry a third of the vote, because there's 3 members in the panel. So I'm not sure whether you would want to exclude someone on the basis of that, but I would think anybody, my own feeling is, if a former member is applying for this, it's because they've retired from politics, but they've got an interest in terms of being here and having the knowledge of how the place works.
I was just on Nuala's point. I know the temporary appointments are in MLA, but see, it's in clause 4 actually. But why the provision for temporary appointments wasn't in the original 2011 Act? What was the basis of making that change?
Well, I wasn't here back in 2011, and to understand why they didn't do it then. Is that something that perhaps I looked at Trevor, were you here then?
I was, but I can't actually remember that far back.
Well, do you know what the basis was for including this now?
I think this was just to, Chair, with permission, this was really just to allow for those an opportunity to put in a temporary appointment, because it made sense and it was a reasonable thing to do, and that was not in the previous legislation. So I think that was the basis of the policy decision. And that's a reasonable and sensible thing to do if you need a temporary appointment made. So it's an addition and an enhancement of the previous arrangements.
And the intention of the Commission is that to remove that kind of the power that might perhaps be seen as an abuse or way to get round the rules. It's something that we have discussed at our past Commission, but after the bill was introduced, so we will be seeking to amend it. But I know I can speak for all of the Commission members here, that if the point that you raised about MLAs, former members, and them wanting to stand again, it's something that we're willing to look at, and with regards to an amendment, whether it needs to happen or not.
Could I come in just on that point as well? We have also become aware since the previous legislation was drafted on other occasions with other bodies whereby vacancies have arisen and the legislation hasn't enabled the appointment of a temporary appointment. So whenever we were considering the amendments to this bill, there were a number of areas that we decided we should take further robust measures to put arrangements like that in place, because we are aware of problems that have been caused in other areas because there was no provision for temporary appointments, and that's just one of the areas where I say we've tried to make the 2011 Act a bit more robust on some of those aspects.
Sorry, can I just come in with a question now? Just to pick up on Nuala's point there about the Assembly Commission having no role in the appointments process, I wonder, could you outline what will happen in terms of setting the criteria and how we'll take it forward?
So whenever this process is finished, if it gets finished,
yes,
and the ad hoc's finished their piece of work,
yes,
as was read in the chamber this week, it's handed over to the Clerk Chief Executive and other professionals to actually appoint that body. The Commission themselves will have no part in any part of that selection process.
Sure. Would it be appropriate then for you to maybe outline how you feel it'll go forward from there?
Yes, so I obviously haven't done anything at this stage because obviously we're just progressing the bill, but it would be up to me then to establish a panel of suitably qualified individuals, and then I would sit down with those panel members and we would establish what the criteria should be. So you will see that in the bill and even in the Act at the minute, there is no specific criteria in terms of specific individuals that must be, or types of individuals that must be on that panel. So that is something that I would work with the panel members, and that's how we would normally progress any recruitment competition, that the panel would establish the criteria then for the appointment.
Can I maybe just actually add, I think it's important it's done that way as well, Paula.
No,
because
I'm just asking.
because if we set our criteria, then there's an inference that we got involved in the process. We want no part in the process as commissioner members, and that's why we're doing it the way we're doing it. And when we get it, if the legislation passes, that we believe in the chief executive's best place to do that, and then there can be no accusations that members was involved at setting their criteria to appoint those individuals.
A point of clarification. See, in terms of, obviously there's nothing then, if this passes, to prevent a former member being on the panel. That being said, there's also, if a former member did apply, and we should never assume that they will, or what their views will be, because we don't know. But if they do, that does not guarantee the fact that there will be at least one former MLA on it. The point being is that if you had 10 applicants and 2 former MLAs were part of that, what I'm saying is it doesn't mean that there will be a former MLA. Technically, it means that there can be no former MLA appointed even though they've applied, is my point.
Yeah, it just allows them to apply.
Yeah.
It's supposed to be completely on merit.
I think it's also worth pointing out that again, pointing back to Westminster, where this has been accepted practice for a long period of time, they legally require that there must be one of the members of their panel must be a former MP. And if we look at just 2 weeks ago, I mean, they went through their process as they always do. And if we look at MPs, Sinn Féin, DUP, SDLP, Alliance, UUP, and TUV, we all have MPs, and there was no discussion by any of those elected representatives to say that they felt that process was carried out inappropriately because there was a former member on the board. So I know there has been discussion about it, but I think what works in one place and works well and has public support, I don't think it's the worst practice for us to try and replicate here.
Sinead, you had confirmed it in the chamber earlier this week, rather, one of the concerns raised was that a former MLA, if they were appointed, could change their pension. But you made clear that there's no retrospective changes to pension entitlement.
Yeah, that's my understanding. So this was dealing with pensions going forward. Pensions accrued by members who have been previous members are what they are, and my understanding, and correct me if I'm wrong, that can't be changed. So what we're looking at is future proofing. So it's for members now and their future pension entitlement. I'm
putting the right court, Chair, and I should declare my biometric a pension trustee, but there's nothing to say in the back of all of this that there will be changes. So we're working on the assumption there is changes even to the pensions. There's nothing to say there will be, but I think it's clear as what Sinead has said that it wouldn't be retrospective in that regard.
Chair, perhaps just for the sake of completeness, just to note that at any one time no more than one board member can be a former member of the Assembly. I think that's an important point to note. That's been incorporated.
Padraig?
Thanks, Chair. Look, it was just to come back around the temporary appointments first. Just, and apologies if I've missed it, would the panel be able to just clarify in terms of the actual appointment process for a temporary employee? And then was just going to, with your permission, Chair, just go on to clause 6. So just a few questions around that, or happy to go back.
No, that's fair enough, no problem.
I maybe pick up on the temporary employment. So again, that would really be up to me. So in terms of any temporary appointments, that would be the same process as the permanent appointments. That would be up to me to
no rule by the
consider.
Commission.
There'd be no rule by the Commission.
Okay, thanks for that clarification.
You want to move on to clause 6 then, Padraig?
Yeah, is that okay? Do you want to...
Anybody have anything 1 to 5?
Yeah.
Yep, go ahead, Padraig.
I want to come back.
I'll come back to you. Go ahead, Padraig.
Yeah, I'll come back.
Yeah.
Go ahead, sorry.
Thanks. Am I right to go on?
Yeah, go ahead, Padraig, sorry.
No problem. So it's just around the board of 3. Just I suppose why 3, or kind of what was the thought process behind that? And then I suppose, are there disadvantages, or would you consider there being disadvantages to having more members on that, or why was that number decided on? It's just to get the clarification on that point.
If we look back, Chair, at the panel was 3, and whilst some of us are critical about some of the decisions, I think actually sometimes these things become big. They're probably more difficult to manage. So 3 worked in terms of there's an independence, it's a broad spectrum of people, and as the Clerk Chief Executive has said, when part of the criteria will be professional people, so that expertise I think is suffice, and that's why we landed at 3.
And I also had maybe put as well that the three that previously on the former board, they looked at wages, pensions and allowances. This new panel is simply looking at wages, so therefore it's got less of a role and it has the same number of people as there was previously. So I think we're all under pressure to make sure that any public boards are as suitably sized as possible, that we're not spending more than we have to. So I think 3 previously, 3 this time, and it's got a smaller task to do. It would have seemed weird to have gone for a bigger board in that instance.
Yeah. No, that's fair enough. And I suppose because one of the questions that I had around that was around, I suppose, the breadth of experience and knowledge. But as you've mentioned, it's for a specific targeted, I suppose, aim and objective, and so that actually allows it to be, I suppose, more concise. So look, thanks for your clarification on that.
Thank you. Paula.
Yeah, if just clause 4, subsection 6A 7 and 6A 8 allows for the Commission by order to make provisions about appointments, and those orders not being made unless laid before and approved by resolution of the Assembly. So can you confirm which committee will scrutinise that statutory rule? Do we know?
Well, to Tara.
I don't think that's been confirmed yet, which committee that would be.
Okay.
But it would then go on to be by affirmative resolution, go before the Assembly.
Okay, and then the second part, maybe looking to the future a bit, is around we as a committee would put out a call for evidence, or put out a call this week. And I suppose some of the public narrative around this in recent weeks has been around the lack of consultation. So if the members could maybe talk to how this will be consulted upon, where the greater public will get an input into the future, please.
Well, if I could take that one, it's I suppose it's right and proper that the public are consulted on matters that are of importance. But if we look back at the narrative over the last number of weeks, it's been about how much MLAs will get and what the pay scale should be, and that this bill is simply about regularising. It's a very technical piece of legislation to regularise a previous decision that was made. As we currently sit, we have the potential for 2 separate authorities to be making decisions about our allowances. There's the old panel and there's the existing powers that are given to the Commission. So in order to regularise that, what's actually happening is, in terms of the old panel, we're divorcing out, separating out the roles and leaving simply an independent panel that in its own way will consult and look at any of the increases there are to wages in the future. But our role with this bill is simply about putting that board in place. That board will make decisions that currently will impact 90 people. So we have consulted with, through the structures of the Assembly, the 90 people that will be impacted. But there's no member of the public that will be impacted by this. But once this board's appointed, if it then decides that it wants to increase or decrease or hold static the wages of MLAs, that may have an impact on the public person. They may want to go out and consult with the public. But for this very technical piece of legislation, which is simply regularising what was there, it doesn't impact, in a sense, people. So to go out and consult with them wouldn't provide any help or assistance to them or to us, and it would just cost money. And actually getting the thing in place, allowing the panel to be populated, they then go and make their determination. If that does impact the public person, then they will want to go out and consult with the public, and they can do that.
And of course then there is the draft report. So I presume at that time then there'll be a consultation at that period, but it'll be at that stage as opposed to before it.
Maybe, Chair, could I come in? And this was just one of the measures that I talked about earlier, where we tried to make the 2011 Act more robust, because previously there wasn't a requirement for formal consultation in that, whereas now we have inserted the clause to make sure that there must be formal consultation by the panel.
And maybe just worth giving some thought where that SR, if there is a temporary appointment, there's no guarantee that there will be a temporary appointment. Obviously, it'll be done by affirmative action, so debated and voted upon in the Assembly. But it may be worth just giving some thought if there is temporary appointments. Do you know, does this ad hoc committee scrutinise that SR, or is there a better body to do that? It's just worth.
Could I maybe come
Yes.
back in? So the bill as it currently stands would enable the Commission to make temporary appointments, but if we wanted to put additional criteria or provision around that, then that's when we would need to bring an order forward. But it does give us the Commission
Yeah.
power to make temporary appointments as it currently stands.
Perfect. Okay, so you covered some in section, in clause 6, so I just wanted to pick up on at least the determination being made at least 6 months before the date of the poll. Just keen to get your commentary on that if possible. Was that to inform potential candidates before the election that they're running in, or what was the thought?
Well, that's exactly it, Chair. I think the purpose of this bill is so that anybody considering putting their name forward for election will know what salary, if they are elected, what salary they can expect to get. And, look, listen, maybe salary as it is at the minute is maybe anybody perspective looking to put their name forward might think, look, it's not really attractive to me, or it could be the opposite way, maybe it's fine as it is. But I think underlying all of it is the fact that I think people need to know what they're signing up for when they put their name down for election. So that's what we wanted to achieve through that, Chair.
Chair, I see, and that same clause was used in the previous bill, not 6 months, not less than 6 months before. That's not to say it could come sooner.
Yeah.
But that's the deadline for it. So for the very reasons that Sinead's outlined, but this is similar to the last legislation.
And maybe, Chair, if I could come back in, you asked at the start about some of the issues with the previous determination and so on, and the issues previously were that came out very late in the day and it was very close to the date of the election. So again, this is one of the areas again where we've tried to make the bill more robust so that the determinations are produced in a suitable advance period before the election, and as Sinead said, that candidates then know what their remuneration is likely to be.
Yes, of course.
Just a more general question, not just about the 6 months before the date, but a general question about timing. Why is this coming before us now? Why this has been sort of ongoing for quite a while. Why are we looking at it now?
Well, I mean, its passage started, and as Sinead said, in June 2020. And then obviously everybody knows what happened at that time in terms of when we came back here in COVID. So this was put in the back burner. If we had continued on at that stage, this would have been in place and it wouldn't have been part of today's discussion. So, I mean, clearly with Assembly being down and all of the other problems that we had at that period. So that's why it's on the table now. But it's key, it's actually a good question in the sense that the public need to be aware that this was introduced in June 20.
Mm-hmm.
In essence, we're 5 years too late with this, where it's not just playing a wee bit of catch-up, we're playing a significant amount of catch-up with this. It really should have been done at that time, but as Trevor has said, COVID and other things got in the way. People did not want these discussions whenever there was conversations of other natures that needed to be there to help people. So, and it's just, this is the time that we've got round to being able to do it.
This is the first available time then,
Yep.
more or less. Okay, thank you.
Okay, and then my only final question, just in relation to clause 6, which I think you maybe covered already, in terms of giving the board the freedom, whatever decision they make, to consult with whoever they deem appropriate. So the commission or the bill does not tie the hands of the board, that they can engage in whatever consultation they believe appropriate. From your perspective, do you think that's an important clause to give them the ability to do that, and not be specified by members how they carry out their work?
Well, yes, I mean, it wouldn't be independent otherwise, so it's really important that it's independent. The other option for this, if we don't go down the independent route, is MLAs having a say in their salaries, and it's not appropriate. And so I think that's really important, that we should not have been at any stage dictating who they should or should not consult with.
And I think, Chair, Leslie, I'm sure, will put in place a robust recruitment and selection process. So, we want the best people to help, establish and to look at these matters. So, we're leaving it entirely in their hands. As Noli said, it's completely independent. It's not for us to dictate. And whatever they deem fit in terms of a consultation, then that is what will happen.
That's both in terms of scope and timescale. And
I think it's important, as a commission, as 5 representatives of the 5 parties, the word independent is said so many times in the meeting. We literally do not want to be setting the wages of MLAs. That's not a task for us. The public don't want us to do it. We don't want to do it. And if we've got an independent panel that can move our wages up, move our wages down or keep our wages the same. Whoever that panel wants to go and talk to get the best evidence for them to do that. We want them to have that. This is nothing to do. We don't want to be setting this. That's why it's going to an independent panel.
Thank you, Chair. The 2016 determination, how was that? How were MLA salaries determined then? And was there a range of options, or was it just a figure put forward? And how would you envisage that there will be a figure put forward this time, or will there be a range of options for the clerk to consider assembly?
So in terms of a figure coming forward, if I can remember right, there was an interim process in that as well, and there was a draft, and they went and spoke to members. But I would say is that I don't actually believe at that time, as a member at that time, they didn't listen to some of our concerns. Some of those concerns we actually addressed, more so in the allowances rather than our salaries. They didn't listen to our concerns, went on ahead. But there's nothing to prevent that from happening again, of course, in terms of salaries. But the process, it was lengthy the previous time, but then their work was lengthier and wider scope.
Do we know how they settled at the 50,500 or whatever it was at that time?
No, they came with a figure. There's no rationale given. Okay. If I listened to the radio last week again, or I think it was last week, I heard one of the panel members talking about the 65% of Westminster's wages. Okay. So they did take regard to Westminster.
Okay, thank you, Chair.
Anyone else? Any other questions on sections or on clause 6, 7, 8? Then we move then to, so they're minor consequentials, continuity of law, interpretation and commencement, which are obviously legally required for any bill, so I have nothing on any of those. Andy, is there anything you wanted to add at this stage?
There's not, Chair. Nope. The others have covered everything.
No problem at all. Any other member have anything they wish to add at this stage?
Just to say thanks, Chair, and we're available at the committee's behest throughout your process of scrutinising this bill.
And then just the one point is just, and obviously we're nowhere near that stage yet if the bill passes, but just if we can give some thought, Standing Order 43 requires that any statutory rule before going to the Assembly is referred to an appropriate committee, so maybe we should give some thought to what that appropriate committee is. At least we're then able to answer that, and if members have any questions on that, if that's possible. Okay, listen, thank you so much for your time, and thank you also for the work you do as a commission. You ensure the smooth operation of the Assembly. I thank this task on some occasions, but greatly appreciated, so thank you very much.
Thank you.
Thank you.
I am conscious of throwing my coat on to get the elbowy right, which would be good.
Colleagues, I just had outstanding information in relation to where that SR would go to if required. Obviously, there's no guarantee that it will ever come because it's only if changes take place, but I think it's just for belts and braces, it's worth us seeking clarity on that. Is there any other information at this stage members are looking to seek from the Commission, or are they satisfied with the evidence they've got so far?
No, I think, didn't we agree on Tuesday that we are commissioning our own research?
Yes.
Yeah, so I think that because even some of the stuff I was going to ask there, I thought will probably get brought to our attention.
So on Tuesday we'll have research from Ray's, and then if we have any further questions at that stage or at any stage throughout the process, we can then contact the Commission to seek further information on that.
Sure. Can we ask for the Commission to come back again if once we get the research?
Yep,
okay.
We can. They can come back at any point in that correct?
That's correct, yes. The Commission can be asked at any point, but I mean, I would suspect the committee will want to get them back at the very least after all the evidence comes in to answer questions on what evidence has been received.
Okay, perfect. We then move to item 6, members, which is correspondence, and that's at page 69, which is tab 6 of the meeting pack, and this is to note correspondence from the Bill Office confirming the commencement of the committee stage of the Assembly Member Remuneration Bill on the 18th of February. Members content to note?
Yes.
Okay, thank you. We then move to item 7, which is draft forward work plan at page 71. At the previous meeting, the committee agreed to ask the examiner for statutory rules to provide advice on delegated powers in the bill, which will take place, and then Tuesday we have the evidence from Ray's. Is that correct, Jim?
That's correct, yes.
Is there anything else you want to highlight on the forward work plan at this stage?
No, there's nothing. We're pushing to get evidence sessions as agreed last week, and any further evidence sessions possibly arising out of the race paper can be considered by the committee next week.
So on Tuesday then we'll consider that research paper, and then at that stage members will then be able to formulate further questions, also further evidence and further witnesses that we may wish to hear from. Are members content to agree the forward work plan then at this stage? Okay. Is there any other business at this stage then, members? Members want to raise? So we're back on Tuesday in room 21.
In room 29? 30. Yeah, we're movable feast.
Yeah, at 1 p.m. Okay, thank you very much for your attendance, and the committee is adjourned, and we'll be back on Tuesday next week. Thank you very much indeed.
Committee Room 21. Sound. Committee Room 21. Sound. Committee Room 21. Sound. Committee Room 21. Sound.